Hello and welcome. You're watching NDTV, and the big story, we're now tracking the various cases regarding the Gyanvapirow mosque. Now first, the case will be coming up in the local court in Varanasi. This is regarding the survey of the Gyanvapirow mosque complex. Also, the matter will be coming up in the Supreme Court where the mosque management has petitioned against this survey being conducted in the first place. We're joined now by Sanket and also Alok joining us from Varanasi, where that hearing is going to take place in a short while from now. Alok, what is the latest you can share with us? And also there's another petition that has been filed now regarding the claims that were made yesterday about a shivling having been discovered, and now based on that a fresh petition has been filed.
Well, yes, you are right, but I think, like I said, it would be pertinent to wait to see whether the court actually accepts the petition or says anything about it before we talk about it, because it is a matter of very sensitive nature. I'll first go and tell you what is going to happen today. Somebody just asked, if there is going to be a delay in the filing of the report, then what will the court hear? And it's a very pertinent question, because at 2 p.m. there are 2 or 3 things that are expected to happen. Number one, like we've been reporting, the court appointed advocates who acted as commissioners in this entire survey of the Gyanvapirow mosque. They have put up an application saying that they want 2 more days to complete their report. Now it is up to the judge to consider that, whether he accepts that it can be done in 2 days, whether he wants a shorter time frame, whether he wants a longer time frame. That's one of the things that will be decided. An advocate for the government, because the government is also a party, has also approached the court, and that gentleman has filed an application saying that, because that entire area in the Gyanvapirow mosque, which is where the wazoo takes place, that has been sealed off. That is leading to problems for people who are coming into the mosque to pray, and also problems because it's a pond, a tank, and that's why there are fishes, etc. inside. So that petition prays for the appointment of a fresh court commissioner who can go back to that area and actually take a call on what to do with it, whether that area should remain sealed or whether there can be a workaround. So that's number 2. Number 3, like you pointed out, the petitioners, 3 of the women who are part of the original petition that led to the survey happen in the first place, have approached court asking for another survey, if I can put it that way right now. So they've asked for a fresh survey in some part of the mosque. Whether that is allowed or not, we wait to see. The language of that petition, like I said, is very sensitive, so I don't want to talk about it till the court actually accepts it, or the court makes a remark on it, or whether the court rejects it. So let's just wait for that to happen. But I think the larger picture of that petition is that they want a fresh survey in some parts of the mosque. So these are the 3 things that are likely to be taken up. We are told that it will happen at 2. It could be delayed by a few minutes, but this is what is likely in the lower court here in Varanasi, where I am right now.
Right, and Alok, also, the main focus being on the Supreme Court as well, which is going to take up whether this survey in the first place should be conducted or not.
Well, you are absolutely right. I think that is why, every time we've been discussing this, I've been saying that I think the bigger story today may come out of the Supreme Court of India. But one waits to see when that hearing will happen, because what is being challenged there is the totality of the survey, and the fact that, one of the sides of the Mosque Management Committee is saying that this entire survey order is illegal, and they are of course relying on what they say is the Places of Worship Act, which calls for, not what they say, it is already in existence, but they pray in their petition that because that act is in place, any survey of the mosque is illegal, and that is the plea with which they have gone to the Supreme Court of India. So one waits to see what news is going to come out of there. So I think this is both going to happen simultaneously. On one hand, you're going to have the Supreme Court maybe listen to it around 2 p.m. and the Varanasi court proceedings, we've been told, are going to start at 2 p.m.
Exactly. So 2 p.m. are going to be these 3 big important petitions that are going to be heard, which Alok explained. We are reporting non-stop. It's 1:55 in about 5 minutes from now, Gargi. Yeah. We'll start seeing some movement as far as courts are concerned. Now, Alok, one important point that we saw the Supreme Court make or observe while delivering the Ayodhya verdict was in the context of there not being anything retrogressive in nature, which is why I think they reiterated the essence of the Places of Worship Act 1991, perhaps fearing that something like this is going to happen.
Would be a little difficult perhaps for me to say why they did it, but they certainly did it, right, Sanket? That is not under dispute. They did make an exception for Ayodhya and made it clear that Ayodhya was the only exception. But right now you have a case where a civil suit has been filed about the Gyanvapi mosque, which has led a judge in the lower court to order a survey based on his wisdom or his interpretation of the law. That survey has concluded, even before the report was officially submitted to court, you've had the petitioners, especially from one side, come out and give public statements about what was found, including this alleged shivling that was found in the wuzu area of the mosque. Again, just to point out that you have a situation where the report officially has not even been signed by the court commissioners. They are saying, कि हमको 2 दिन और लगेगा, it will take us another 2 days to prepare the report. And yet you have all of these lawyers coming out and talking about this in absolute finality. And you've had a situation where they have gone to court, prayed that that area be sealed off, and the judge has ordered that the area should be sealed off. So like I said, this is the wisdom of the lower court, and the judge has done it based on, like I said, what is his interpretation of the sequence of events. But the larger overarching picture is before the Supreme
Alok,
Court of India.
What are you hearing as far as the events of yesterday are concerned? I know you have to go inside court, but just wanted to ask you, what have you heard from lawyers from both sides saying about the manner in which yesterday, even before the court commissioners could submit their survey, for there to be this whole conversation around shivling versus fountain, and then eventually moving court and getting an order area sealed also?
No, see, I think there is a distinct divide, right? On one side you have the petitioners, the 5 women, their lawyers. On the other side you have the lawyers for the mosque committee. I think we've all seen what's played out, I mean, on one hand, like I was saying, even before the court appointed advocates or commissioners have gone and prepared the report, signed it, you've had these public statements. The other side has said that, look, it's a fountain. That's what they are saying. They're saying it's a fountain. If it was really a shivling, why would we keep it there for 400 years, etc., etc. So I think the larger story again is this deep, distinct divide that has been created. On one hand, you have this entire narrative of the shivling being found. On the other hand, you have strong denials. This is what we saw yesterday, and this is what we are likely to see today too. But like I said, again, I'm sorry to repeat myself, but I think the most important event today is what happens in Supreme Court.
All right, Alok, we'll let you go now so you can, get us the latest there from the local court in Varanasi. But as Sanket, as Alok said, the main focus is on the Supreme Court. You spoke about, how the Supreme Court during its Ayodhya verdict had reiterated the Places of Worship Act 1991. And the reasons, I think, were quite clear because even, during the whole time of the Ayodhya Mandir, there were all these murmurs of Kashi and Mathura, etc. And I think the Supreme Court in its wisdom had, wanted to put a stop to any more digging up across India.
Yeah,
Perhaps
so
that is the reason.
Gargi, the essence of the Places of Worship Act 1991, because in this context it is being spoken about a lot, was exactly to make sure that a repeat of Ayodhya does not happen in this country. That was the essence of that law. It was opposed by the BJP in 1991 also when P.V. Narasimha Rao government brought it in. And the reason why Ayodhya was an exception to this law is because Ayodhya's was a title suit which was going on. It predated even independence. So while that was on, so the government said, fine, let the courts decide this case and we will not keep it in the ambit of this law, but so that there is no future claim, so that there is no Mathura, so that there is no Kashi and many other places. That's why this law comes into effect. The BJP opposed it back then.
And if you can just explain for viewers what exactly this law entails.
Okay, so the Places of Worship Act 1991 basically says that the religious structure of a place shall stand the way it is as it was on the 15th of August 1947 minus Ayodhya. That is what the Places of Worship Act was. It prohibits the conversion of any place into some other religious structure simply because somebody feels that 200 or 300 or 400 years ago it was something else. Now most of the people who are either BJP supporters or who are BJP leaders themselves are saying that when you say an original place of worship, do you consider the fact that a structure was built on top of an existing structure, which means, let's just say for argument, in Kashi, the contention is that there was a temple and on top of that temple a mosque has been built. That is the claim that is being made. So many leaders of the BJP, also lawyers, they say that then by that logic, should we be considering Gyanvapi as a mosque or a temple on top of which a mosque has been built? And in that context, should we not find out, should there be not surveys to find out what really the truth was? See, the point is, and here is where politics comes into the picture, Gargi.
Right.
If this is a purely academic exercise, then nobody can have an objection. Why can't you have an academic exercise? The Archaeological Survey of India has been digging. I mean, the entire findings in Rakhigadi are a great achievement for the Archaeological Survey of India. We're getting to know more. It's an academic exercise. We are learning more about history. But the point is, and that is where politics comes into the picture, is this survey or will this survey be used to alter the religious nature of this mosque? That is most important.
All right,
and the point is, when you speak to people in the BJP, in hush-hush tones, they do admit that we need to revisit the Places of Worship Act as well. Because the moment you alter Places of Worship Act, then the road is clear. This is the only thing that stands in the way of converting places of worship.
All right, and then we'll have many more petitions regarding many other areas, I'm sure. Well, let's go across to Arvind, who joins us from the Supreme Court. Arvind, what's the latest there?
Gargi, the Supreme Court will be shortly hearing this particular appeal that has been filed by the management committee of the mosque, challenging the Allahabad High Court order. So Allahabad High Court had allowed the conduct of the survey in the mosque in Gyanvapi that has been challenged by the Masjid Committee here in the Supreme Court. So though the survey process has been completed, but still the report is yet to be submitted. So the matter has not yet become infectious. Only the survey has been completed, but the report is yet to be submitted before the competent court by the court-appointed committees or the surveyors. So that has been challenged by the Masjid Committee here in the Supreme Court, and Supreme Court shortly will hear the bench led by Justice D.Y. Chandrachud and Justice Narasimha will be hearing this appeal against the Allahabad High Court order that paved way for this particular surveying in that particular mosque. So the matter will be heard in some half an hour also. Also, very importantly, the Hindu Sena has also filed an intervening application in this particular matter, wherein they had asked the Supreme Court not to pass any order on the plea by the Masjid side, saying that they should also be heard in this particular matter because they are also a stakeholder in this matter. So the Supreme Court has not given any go-ahead for the intervening application to be intervened in this particular matter. They have just asked the intervening side, that is the Hindu Sena side, to be present in the court when the matter is taken up for the hearing. So when the matter is taken up for the hearing, sometime we are expecting somewhere around 3 o'clock, that's when we'll get to know whether the Supreme Court will allow the Hindu Sena side to intervene. That's one thing. Also,
and do we know what their intervention is, Arvind? Do we know what exactly their contention is in this entire matter?
Gargi, what they are saying is that as a stakeholder in this particular matter, so they also should be heard. Hindu Sena being a body that represents the Hindus, they also want to be heard in this particular matter. The main contention is that Supreme Court should not hear only the appeal preferred by the Masjid Committee and then pass any order. In fact, they should also be heard because they are also stakeholder in the matter, and that's why they should be allowed to intervene in this matter. That's the main ground on which are the main contention that is yet to be cleared by the Supreme Court for now. So for now, Supreme Court will first hear the appeal preferred by the Masjid Committee, wherein they have challenged this entire survey process. So that will be heard alongside the intervening application might also be heard by the Supreme Court, something we can hear post 3 o'clock.
That's right. Arvind, I distinctly remember November 2019, Gargi, Arvind and I were in the lawns of the Supreme Court reporting on the Ram Temple judgment. And Arvind, we read out the portion of the order where it was clearly mentioned that while a judgment in Ayodhya is being delivered, there should be a very strong stress on the fact that this is not repeated and the essence of the Places of Worship Act is implemented. Now, in the very same Supreme Court, a lot of people, a lot of lawyers, namely Mr. Ashwini Upadhyay, who's also, there are articles written about him, Arvind, that he is not a public interest litigation expert, but a political interest litigation expert on behalf of the BJP, because he's a BJP leader also. Now he challenges the Places of Worship Act itself. when is the court likely, or is the court likely to touch upon this act itself? Because, you know, some of those lawyers who pronounced that judgment are hearing this case as well.
Yeah, Sanket, in fact, if you could read the Ayodhya judgment, Places of Worship Act had its own place in that particular judgment. And if you could remember it, that particular judgment was given, the Supreme Court invoked its extraordinary power under Article 142 to ensure that the justice is met. So that's why the Supreme Court invoked that 142 also while giving the land to the mosque side also. So Places of Worship Act had its own place in that particular judgment. Now, if either of the parties are challenging the Places of Worship Act per se, then that's something that Supreme Court, we are not sure whether the Supreme Court will entertain that plea at this particular point of view. Like Gargi and you were explaining, that will open a Pandora box. Because getting into Places of Worship Act, Supreme Court will be very cautious because they will be putting the ball back into the legislature to get into the domain of that. But coming to this very important point that you raised about this hearing, because Justice D.Y. Chandrachud and Justice Narasimha, who has been recently elevated into Supreme Court, so both of them will be hearing this matter somewhere around post 3 o'clock, where both the sides, some of the lawyers who appeared for the parties in the Ayodhya matter will also be representing either side or both the sides in this particular matter. So we have to wait and watch how the Supreme Court will take this matter into, because the survey is done, but the report is yet to be submitted. So that's the catch point here. So Supreme Court will be cautious of that particular factor, and then we have to wait what will be the interim arrangement of Supreme Court.
Okay, Arvind, in the next 50 minutes or so, Gargi, we should have clarity on what these courts observe or what order do they give. The latest breaking news that we are getting from our colleague Saurabh Shukla is that the hearing in the Varanasi court has now begun. Two things that are going to happen in the Varanasi court. Number one, whether it admits this brand new petition which has been introduced, where the petitioners are saying that in light of these fresh revelations of whether it is a shivling or a fountain.
Well, they're going with the assumption that it is a shivling.
They're going by the assumption that this is a shivling, and that action be taken and Lord Nandi be allowed to see the shivling. Now that will involve breaking down a wall. That is the petition.
But this even before the court has accepted the survey findings or they've been submitted in court.
So whether this will be admitted or not is going to be decided in just a short moment from now. Number two, the original case where the court had said that you present in front of us the findings of your survey by the 17th of May. To that, the lawyers or the commissioners, advocate commissioners have said that we have not quite completed our report just yet. We need 2 to 3 more days. So will that time be given by the court or not? So these two things are going to be heard by the Varanasi court. In New Delhi, in the Supreme Court, the Muslim side has now moved the court, saying that we were not even heard when this decision was taken of shutting down our Wazukhana, and also the manner in which this survey is being conducted. We are not satisfied with the order of the local court in Varanasi. That's why they've moved the Supreme Court. So 3 crucial things that are going to happen as far as these petitions are concerned. In Varanasi, Gargi, as we mentioned, the proceedings have now begun.
All right, and waiting for the proceedings here in the Supreme Court, which obviously are the more important, proceedings, and the hearing to take place in which the mosque management has contested the fact that the survey is taking place. We're joined now by Aashutoshsrivastava, advocate Supreme Court and someone who supports the BJP, also Kapil Madan, an advocate of the Supreme Court as well. So very, very key hearing taking place in the Supreme Court, and we'll know whether we're going to, be talking about this a lot more going forward. First, your comments, Aashutoshsrivastava.
Yes, we have to see whether Supreme Court decides to intervene in the matter or not, because every appeal is not entertained by the Supreme Court unless and until there is some merit. My view would be the court will only see that the interim order which has been passed by the trial court regarding the survey of the area, whether that order was within the purview of the law or not, and whether this is the right stage to intervene in the matter or not. Because see, as we know that the Places of Worship Act has also got certain exceptions. Like one of the exceptions we have already seen in the Ram Jan Bhumi issue, which was, which was under the exception, and this law did not apply. Accordingly, there are certain other exceptions as well.
Would you like to elaborate, sir?
Yes.
The other exception?
The first exception is that if a place of religious activity has changed its character after 15th of August 1947, then the provisions of this Places of Worship Act 1991
when was the Gyanvapi mosque built?
Now I'm coming to the second one. Now we have to see which exception it falls under, if that is so. Now the second exception is important. It says that if a place having any ancient monument value, and if it comes under the provisions of the Ancient Monument and Archaeological Sites and Remains Act 1958, and the monument is like more than 100 years old, then in that case, the provisions of, the Places of Worship Act will not apply. So now we have to see whether it falls any of these exceptions.
Right.
Now the third exception is, yes, there is a third exception which says that if there is any sort of settlement between the parties, or if there is any matter is disposed of, then in that case, the provisions of the Places of Worship Act will not apply. So now I think the third is obviously doesn't apply here, but whether any of these exceptions, one or two, apply or not, that has to be seen further.
Right. Kapil Madan, your view on that, because more and more we're hearing people talking about, how this complex and the entire Kashi Vishwanath temple complex falls under this Ancient Monuments, Archaeological Sites Act. What is your view of this?
So Nidhi, I will make two legal and technical points here. The point number one is that let's look at from where
Mr. Madan, I really apologize. I'm going to come back to you. There's some breaking news that we are getting as of this moment. Our colleague Saurabh Shukla as well as Alok Pandey are getting information from a Varanasi court. Saurabh Shukla reports that Alok Nath Yadav, who is the lawyer from the Gyanvapi Masjid, he says कोर्ट का आदेश था कि सर्वे की कार्रवाई बिल्कुल गोपनीय रहेगी, पर बाहर मीडिया में आके जोर-जोर से पक्षकारों ने सर्वे की जानकारी दी, which is
something we were talking about as well.
So the lawyers have very clearly mentioned that this was supposed to be in a sealed envelope. It was supposed to be a secret, the findings of the survey. However, they were made very, very public and very, very open in the media, which is a violation of what the court had ordered. ये कोर्ट के आदेश का उल्लंघन है. And while all of this is happening, Alok Pandey now reports that Gargi, there are heated arguments taking place in the Varanasi court, where both sets of advocates are shouting at the top of their voice in the presence of the judge. Pretty much like a TV debate.
All right, so that is what's going on in the local court. We're waiting for the Supreme Court hearing to begin. But yes, Kapil Madan, we were, discussing this issue of ancient archaeological sites and, whether there is some sort of Ancient Monuments Act, whether that is something that comes into play here, because that is something that those who are supporting the fact that there's a temple under the mosque are, talking about more and more.
So let me respond. I have two short points to make. Point number one is, if you look at the context, if you look at the historical history of this case, how this was started, it was basically started where one of the petitioners said that they wanted to pray at the disputed site for all year along. There are reports to say that they can pray for one day. However, they said they should be allowed to pray for the entire year. Now look at how the nature of the case is being changed. Now if the fact remains, if you want to pray at the site and you were already praying at the site, albeit only for a day, then this entire exercise of survey, what was there, whether there is a shivling, what was the historical background of the case. To me, it looks like an exercise in futility, because the very exercise which you are trying to do is barred by the express provision of the law, which is section 3 of the Places of Worship Act, which clearly says, 4 of the Places of Worship Act, which clearly says that you can't change the religious character of any place. It shall continue to remain the way it was before 1947. So your fact finding is only limited to the relief that the petitioner is trying to ask. Now, be that as it may, we don't know what was there. If you want to do an academic exercise, then perhaps you can't do it in this particular proceedings. You initiate any other proceeding, but to carry out a proceeding which is...
No, so you're basically saying that the survey itself carries no meaning.
I agree with you. That's the point I'm trying to make.
I am only repeating what you are saying.
I am saying the dispute, the petition. See, you have to see the suit and the prayer, the ultimate relief which you are seeking in the suit. And
I think that's the reason why this matter has gone to this exact angle, whether the survey itself should be ordered or not has gone to the Supreme Court also. In the meanwhile, some more information coming in from Alok Pandey, Gargi. He says the lawyers for the petitioners asking for a fresh survey inside the mosque. This is that petition number 3 that we were talking about, related to the new petition filed by 3 of the women asking for a door to be opened or broken to further investigate the contours of the quote-unquote shivling. In the meantime, the court-appointed advocate commissioner has requested the court to grant him 2 more days of additional time to submit the survey findings.
So the survey has still not been submitted. Remember, it was meant to be submitted today. However, as we've been saying and reporting on NDTV, we interviewed one of the surveyors as well, and he said that he needs 2 to 3 more days. The issue is also that this survey was meant to be submitted to the court in secret, in a document,
and
in a sealed document, and it wasn't
now
meant to come out in the media. Except that yesterday we had all these chants of Har Har Mahadev and shouting that the shivling was found, Baba was found, and then what have you, this situation. Though at the same time the lawyer for the Hindu side did approach the court, Sanket, and the court did admit that plea and did not say anything about the shivling, but did ask for the pond area, the Bazu Khana, to be sealed.
The latest is that Mr. Yadav, who is Abhaynath Yadav, who is the lawyer for the mosque committee, he is repeatedly saying that no fresh petition should be entertained till such time that the committee submits its report. That means till such time that the survey report is submitted and the court is apprised of the matter, they can study in detail what exactly are the findings. No such petition must be filed. Now, latest coming in, this is information from Saurabh Shukla, Hindu Paksh. I'll translate it as I speak. हमने नई application लगाई है, which means that the Hindu side is saying that we have filed a new application. हम मांग करते हैं कि दीवार हटाकर हमें मलबा हटाकर शिवलिंग की लंबाई चौड़ाई नापने की इजाजत दी जाए, which means that we must be allowed to remove the wall which is covering what they claim is a shivling. That wall must go, and we must be allowed to measure the size of the what they claim is a shivling. इसका नया सर्वे कराया जाए, which means a brand new survey must be conducted. कोर्ट इस कार्रवाई के लिए कोर्ट कमिश्नर नियुक्त करे, which means that the prayer is, Gargi, that there be a fresh survey under a fresh advocate commissioner. This apart from the survey.
And this when the survey has not yet been admitted.
Completed.
Yeah, has not been given to the court. So that's what's happening at the local court level, and we're waiting for more, information from our reporters there.
Yeah.
But the hearing at the Supreme Court is what we're waiting for right now. And Aashutoshsrivastava, again, we're waiting for what the Supreme Court will rule on this. But really, it would open a Pandora's box. Is the reason why you have this Places of Worship Act? It's because if this is allowed, then the worry is that all over the country such petitions are going to be filed, and pleas being made about ancient temples, under mosques, etc.
See, the purpose of enacting such law in 1991, the Places of Worship Act, was the same. However, there were certain exceptions which were mentioned, because in these kind of extreme cases where there are sufficient evidences available, so in those kind of cases, people should not suffer. If anybody feels that their constitutional right has been violated, they can approach the court. And if there are certain exceptions which can fall under these kind of cases, then obviously they have the right.
I'm trying to understand, Mr. Srivastava, one very simple question. Are you suggesting that, and we have seen many lawyers in the Supreme Court, namely Mr. Ashwini Upadhyay of the BJP, who says that it is now time, and this is BJP's stated position. They were upset with the fact that Places of Worship Act came into existence in 1991. By the way, they walked out of Parliament. They walked out of Parliament back then. Are you saying that once it is, as part of this academic exercise, once you figure out whether this was a temple or a mosque, and if it in the findings, and I'm assuming a number of things, if it is found out that this was indeed built on top of a temple, are you suggesting that we must hunt for exceptions or do away with a law which alters the religious nature of this building?
See,
will that be correct? Will that not go against the spirit of what the court said in November 2019 while delivering the Ram temple
where they
judgment?
reiterated this?
No, court didn't say anything contrary to the law. The court was very well within the ambit of the law which has been enacted in 1991, and nobody is against it. There are, the exceptions cannot be read in further exceptions. See, there was exception so far as Ram Janmabhoomi is concerned, and that is why this matter could have been decided by the Supreme Court. Otherwise, there was no provision only to decide. Now, with the same set of facts and the legal provisions, there are other exceptions. So why those other exceptions should not be read out or to be availed by the people who think that this particular issue falls under the exception of that act?
Well, there could be many exceptions then raised. Kapil Madan, I'd like to get your view on this.
That could be.
Right, let's get Kapil in here. Kapil Madan, your view on this.
So let me respond, and let us see what the Supreme Court is examining. The Supreme Court is examining the fact that whether the order passed in the absence without giving notice to the other side by the trial court, whether this order is correct or not. To my mind, the rule of natural justice clearly says that if you want to pass an order against any party, you should give an opportunity of being heard, which is called alterum partem rule in our jurisprudence that mandates that you should give an opportunity of being heard to the other side, which is the affected party. So to my mind, it appears to me that in this case, prima facie, that has been violated, and the Supreme Court will take a cognizance of that. Now, let me respond to the question here. My learned friend is here that there is an exception under the Places of Worship Act, and he is coming under the exception. Now, let us see in the context of what the dispute is before the trial court. The dispute is not whether it is mandir or it was a masjid and what is the historical background. Now, the petitioner is basically praying that he should be allowed to pray there for the entire year. Now, if this is the dispute, then why this survey is required? You are changing the goalpost. You are basically changing the entire nature of the dispute, and it is going in altogether a different direction. If there is a prayer, you need to argue and give evidence for the facts which are in issue between the parties, which will be in aid to the main prayer that the petitioner is trying to seek before the court. If you are going in all the directions, to my mind, it appears, even if my learned friend says that no, this is covered under the exception, to my mind, to my understanding, the very exercise of this survey.
No, and also, by the way, last year there was a petition in a court in Varanasi that the ASI be allowed to carry out a survey, there was a stay order on this by the Allahabad High Court. This is a fresh petition, and I believe now there will be more and more petitions. Pretty much.
Right.
Again,
I want to ask a question. Actually,
you're not political guess. Otherwise, I would have asked you: is this going the Ayodhya way?
Kapil Madan, I'd like to ask you a question about what's happening in Varanasi right now, and the fact that this survey was being done. It was a 3-day survey and was meant to be submitted today to the court in a sealed cover. However, the information leaking out in the manner in which it did, with lawyers claiming a shivling has been found. That too is currently being talked about in the local court today, and the lawyer for the mosque management side is questioning that how could this be leaked out to the media like this?
Before you answer this question, Alok Pandey has just given some fresh information. The court commissioner is, and I'm quoting what Alok is sending, the court commissioner is saying when the survey was under the guidance of the court, why were the videographers on TV giving reactions to the media? He says they have done their work without any bias, and this will reflect in their report. So that's the latest.
So the fact that it leaked out in this manner, your comments on that?
So yes, let me respond. I will just give another. Will cite one legal technical rule that we use, that there should not be any apprehension of bias, and it should not be that you should do justice. The justice seems to have been done. And let me tell you why I am raising this question. Now, there were reports in the media that the trial court that was listening this case, in this order, he has basically written down that he is receiving threat. So when the parties are in dispute, and if you are mentioning in the order that he is receiving threat while he is hearing the same case, and the parties in the case are being apprised of the fact that he is being threatened by any side, to me it is a sufficient reason, or it is a sufficient cause to believe, or there are reasonable apprehensions to say that there could be bias while he is deciding the case. So, and the second aspect is that the report should have been confidential. It is again being leaked in the media. So I would just say that there are some serious legal infirmities in the way the trial court is functioning, and I'm sure the Supreme Court is seasoned of the matter, and they will look into all the aspects of this case and will pass an appropriate order.
Right. This has been spoken on by our reporters as well, even as they were questioning the lawyer, and the lawyer was saying that the shivling has been found, etc. Our reporter did point out, how are you talking to us about it so openly, because isn't this all meant to be a secret right now? But yes, so a lot of questions
I think lawyers are being pulled up. By the way, Gargi, lawyers are being pulled up in court. A lot of questions being raised in the manner in which this
has been
even
done.
In court, where the advocate commissioners are having to convince the court by giving out statements saying हमने बिना भेदभाव के काम किया है, which means that we have not, our report is not biased. मैं अपनी रिपोर्ट बिना भेदभाव के दूंगा. ये दोनों धर्मों की आस्था की बात है. This is a matter of
and very sensitive matter, Sanket, and it to be leaked out in this manner, and all those chants of Har Har Mahadev and Baba Mil Gaya at a time when this was all meant to be done in a very
the court
secret
the court is quipping also, where they're looking at the lawyers and telling them ये बस national channel पे दिखाई देते हैं बस.
All right, well, thank you, gentlemen, for joining us on the program, and we're waiting for the Supreme Court to conduct the hearing and take up the appeal by the mosque management. We'll slip into a short break and return with more.